Welcome to this episode of the DMH Stallard Private Wealth Podcast. I'm Jenny Ray, a partner specialising in contentious probate, and I'm joined today by Nadia Cowdrey, a partner and head of the private client team in Sussex. We're talking today about asset protection. So in England and Wales, we have complete testamentary freedom. However, freedom to leave your estate as you wish doesn't always mean you can control how your assets are distributed, particularly in the longer term. Poor planning can sometimes lead to unforeseen circumstances, unwanted and even undesirable consequences. So, I mean, it's a big topic, isn't it, Nadia? I don't know where the best place to start is. If we maybe talk a little bit about why people might want to consider asset protection and why it's becoming increasingly more common to have to think about this.
Yeah, I mean, a lot of my clients think about asset protection, and everybody's got a different family setup. I mean, a typical case where people would be quite concerned about it is when there's a blended family and, a couple have come together and they both have children from other relationships and they want to provide for each other. But they want to protect assets to make absolutely sure that once they've both gone, that their own children benefit rather than perhaps their stepchildren. So that's a typical scenario where people might be wanting a structure to protect assets.
I suppose that's something we see more and more common, isn't it? As people are living longer and having second families, it's balancing that desire to provide for your spouse or partner and for assets to remain within the family or to pass down through the generations.
Yeah, absolutely. Unless you see sort of families come together whilst children, are particularly small and they come to view them as their own children, and in those scenarios, it's not uncommon, to want to make provision for stepchildren, but certainly sort of, when couples come together with older children from earlier relationships, there would generally be a wish to sort of make sure that everything eventually passes to their own rather than stepchildren.
So, from my perspective, I often come across issues where, for example, somebody has been excluded from an estate, and it may be somebody who is entitled to make a claim for financial provision under the Inheritance Act claim. So, an asset may have been left to either cohabitee or spouse, and the children excluded, or the other way around. An asset or estate's been left to the children and the cohabitee or spouse have been excluded. Now, whilst you can set up your estate in that way and provide for whoever you wish, it's not that straightforward because you can make a claim. And so would people consider putting assets outside the reach of a claim? Is there a way to do that to protect assets?
Yes, you can incorporate a flexible life interest trust in a will, which achieves a number of objectives. So, couples quite understandably want to make provision for each other, but they would also want to make sure that their own children, for instance, from an earlier relationship are provided for. And a flexible life interest trust is a really easy way of doing that because the terms can enable, the surviving spouse or civil partner to carry on occupying a property rent-free after the first death. And it could extend to them having the right to receive income from other assets during their life. And we can also include powers that, if that proved to be insufficient, the trustees, which would typically include the survivor and maybe children and any others that might be appropriate, would have the power to make capital distributions to the spouse or civil partner if that was felt necessary. So it's a really useful tool, making adequate provision, satisfying any potential claim that the spouse or surviving civil partner may have in terms of making suitable provision for them, and making sure that, it ends up in the right hands later on.
Yes, because I often see people sort of trying to set up arrangements themselves whereby they'll transfer the asset to the spouse and rely on the spouse making a will that then passes the asset on to the children. And of course, that doesn't achieve the same goal. You don't have that level of control, and nobody knows what's going to happen in the future. People, as I say at the beginning, people are living a lot longer, and your spouse or cohabitee may go on to have another relationship, another cohabitee, and what's envisaged at the time isn't necessarily what will happen. But I can see that flexible life interest trust um, would mean that there'd been provision, and so a claim wouldn't be necessary, or certainly would be less likely. Are there other reasons why people might want to protect assets? I know people often are concerned about care home fees
Yeah,
being
yeah.
taken from estates.
Yeah, well, there's a number of things that this type of structure addresses, and you've raised one of them. If you leave assets to the survivor, there's nothing to stop them changing their will, so you have absolutely no certainty and control over who might inherit later. You've raised the possibility that, they might have a new relationship, and they may decide that they want to make provision for their new partner. They might also have a new relationship which might go wrong. So they get divorced. And, if you've simply left everything to them outright, you've inflated the matrimonial pots, and part of that might end up, going to another family on divorce.
Yeah.
But the other area where this can also be beneficial is protection from care fees.
Mm.
So if you need care in later life and you don't need nursing level care and it's more lower level social care needs, then you're going to be subject to a means tested assessment. And so the local authority would want to know what assets you've got when working out whether you can afford it or not. So if on the first death everything's passed to the survivor, you've created one big pot that's available to fund those fees. And care over a number of years can be incredibly costly. It's not uncommon these days that for decent quality care you might be paying about £8,000 a month, some more. And the advantage of this is that you could have the structure like I mentioned earlier, stating that, on the first death, the surviving spouse or partner, has a roof over their head for their life, they have an income stream. But if they went into care and the local authority said, well, how much money do you have? Because you're going to have to pay this yourself. They'd be, for instance, saying, well, yes, I live in this house, but I only own half myself. The other half is protected by a trust. And I don't actually own the capital of that trust. It's passing to other people after I've gone. So it's not mine to give. And similarly, any other assets where, the person needing care was getting an income stream, they could only be assessed on what that income is, not the underlying capital that produces it. So you can't ever protect matrimonial assets in their entirety, but you can at least protect half from the impact of any care fees.
And would it also be useful if you had, for example, an intended beneficiary who was vulnerable or concerns that they might dissipate the estate? If they had financial worries or addictive behavior like gambling, is that a way in which asset protection might be used?
Yep, absolutely. I mean, there's different types of trusts that we think about in that scenario. So discretionary trust, where you don't know whether somebody's going to be able to manage their own money, or they're going through a bad patch in life and now wouldn't be a good time for them to inherit. And you might want to, let your trustees decide when in future it's an appropriate stage for them to inherit. They might have, certain special needs and vulnerabilities that, a parent might feel my child could never manage this themselves. And that they might be susceptible to influence by others, and other people might take advantage of their vulnerabilities and sort of try and part them with money.
Yeah.
And so in that situation, trusts are quite useful because you can have trustees that are in charge of looking after things for them and making sure that they're provided for. but without sort of exposing money to sort of third party attack. But when you've got that type of situation, we would be thinking about, do we have a discretionary trust, or do we go for a hybrid type of trust when we've got a disabled beneficiary or a vulnerable beneficiary that have certain tax breaks? And it's quite specialist, and it really depends on sort of each individual situation as to
Of
what type's
course.
most appropriate.
So there's lots of reasons why people will need to consider asset protection, and it's all going to be very particular to their own circumstances. And we've talked a little bit about things that can go wrong if people try to leave an asset to somebody through their will, but people sometimes also try to set up their financial affairs during their lifetime to protect assets. And what can go wrong if you were to, for example, try to gift a property to ring fence that from an estate?
Oh, all kinds of things could go wrong.
Big question.
Yeah, I mean, the the difficulty with gifting property, and particularly the sort of main residence, is the lack of security you would have in the future. It's really quite common for people to come and see me and tell me they trust their children implicitly. They would never do anything to turf them out of their home. And they'd like to gift their property to them, and the child, will allow them to stay there rent free for the rest of their life. And on the face of it, um, they've divested themselves of an asset which might otherwise be taken into account if they ever had to pay care fees. But from an inheritance tax point of view, they haven't actually removed the value from their estate because they're still enjoying an asset which they've actually given away to somebody else. So it's completely ineffective from an inheritance tax point of view. But more crucially, they've lost future choice. And they can't simply decide, when they want to move, if they want to sell the property and maybe go into rent it, downsize, take out an equity release. They're at the behest of the new owners of the property. So it's a very insecure, vulnerable position to be in. Families fall out.
Yeah.
It's not necessarily your children that would do anything intentionally to leave you homeless.
No.
It's more often their partners and other influences in their life that are the issue. So you have to be really careful about doing that. I mean, with other assets, somebody might be trying to remove assets from an estate because they're worried later that a spouse or cohabitee might try to make a claim against the assets, and be successful. So sometimes people think about actually giving that asset away during their lifetime and not necessarily having, the issues we've talked about if it's your main home. But you could, for instance, have an investment property, be happy to give up the income, decide that you don't want the risk of a spouse or cohabitee making a claim against that later and giving it to your children. The trouble is, you can't stop a disgruntled spouse or cohabitee who either hasn't been provided for or they don't think they've had sufficient from making a claim. And although you might think you're home and dry and you've actually already given away the assets, you're not entirely safe because a claimant, as you know, Jenny, could actually ask a court to bring those assets back into account if they could establish the primary motive of making that gift was
absolutely. And it doesn't even have to
claim.
be for the sole purpose of defeating a claim. So there might be other reasons, and defeating a claim is part of it. So provided part of the reasons you've done that is to try and put assets out of reach of a future claim, potentially they could be brought back in. So yes, you need to think very carefully if you're thinking behind it. So we've looked at what not to do, and we've touched a little bit on what you should do, but perhaps we can look in a little bit more detail. So obviously in general terms, I suppose if you're thinking about not providing for somebody who would normally be provided for, particularly financial dependents, partners, cohabitees, spouses. What advice would you be giving to people if they want to exclude somebody like that from their estate?
Well, I mean, the first thing I would be talking to them about is to think long and hard before you exclude somebody. Um, it's the last what you put in your will is the last message in a way to your loved ones, and it's really sad when we see, families that are, relationships have broken down and parents are estranged from children, or maybe one child has gone off the rails and they're estranged, and it leads to really sort of great sadness and heightened emotions. And it does sometimes lead to people coming in to see me to say, I want to cut out my son or daughter. And to be honest, I see my primary duty to them to try and test how serious they are about wanting to do that, because it leaves scars that can never be healed. It's not just the financial provision for your loved ones, their lasting memory of you would be, actually, mum or dad, disowned me, didn't love me. And that's really a powerful and sad thing to be the last sort of chapter really in your life. So that's what I talk to people about initially. But, if having carefully tested, the strength of their views about this and that their willingness to accept that, I encourage them to write a letter to who it is that they're excluding, explaining why. Now, as you know, Jenny, a court doesn't have to take a letter into account, and certainly it shouldn't influence a judge's decision. But judges are humans at the end, human beings at the end of the day, and you can't help but think it may have some influence. But more sort of fundamentally, it might make the potential claimant think twice. If mum or dad are saying, do you remember all these difficult times and how, your sibling was always there for me and you disappeared for 20 years and all those kinds of things, it just might make somebody think twice before making a claim and have some understanding. But the other thing, and it really depends on the circumstances, but if the person making the will still has a relationship with the person they're excluding, if the sort of dynamics of the relationship are right, then I just sometimes think it's a question of managing that potential claimant's expectations. If they're not shocked they've been excluded and they're kind of expecting it, and mum or dad's still around to explain why they're not getting provision. I mean, they might be financially secure. They might have one child that's incredibly financially secure and they think they don't need it. And they might have another child who isn't financially secure and they've decided they need to make greater provision for that child. And in that scenario, I think managing future expectations is a really useful way.
I think that's key, communication, and particularly communicating before you die. I think if it comes as a surprise to people when they're grieving, they can often react in a way that they wouldn't if they're aware that they're not included and the reasons behind that. Definitely.
Yeah. I mean, the other thing that sometimes we think about is, when I have a client that's considering excluding, a potential claimant completely, for instance, a long-term estranged child who invariably will come out of the woodwork after mum or dad have died, is to potentially include a no contest clause, or what people might call a forfeiture clause. But it has to be a gift that's sweet enough to make them think twice about making a claim. There'll be no point saying, here's £100, but if you make a claim, you lose the £100. That's not a lot to be gambling with if you might have the prospect of succeeding in a claim and securing hundreds of thousands of pounds.
Absolutely.
So it's all relative to the size of the estate and the situation. But generally, as you probably know from your work, Jenny, you would be in the will including a legacy, for instance. You might say, I don't know, £50,000
Yes, like so.
But if you make a claim against my estate, you've lost that £50,000 and you're taking your chances in court or trying to reach settlement with whoever it is
Yes.
currently inherits. So they can be strategies. The trouble is, if it's very pointed, it could be like a red rag to a bull.
Yes. Yeah.
And I'm favouring more in these kind of situations of having a general forfeiture clause, which seemingly applies to anybody in the will at the end, as opposed to targeting a specific person that you aren't making as much provision for. It might just sort of temper down react a bit.
Yeah, absolutely.
Exactly. Yeah.
And then in terms of so looking more at not necessarily excluding anybody, but just wanting to ensure that certain assets are passed in a certain way. We've talked a bit about life interest trusts and various types of trusts. Is that usually the best way you would recommend protecting assets?
Yes, trusts are really useful for all kinds of situations. You can't get away from the fact if you leave assets outright, you've lost control of them, and whoever you've left them to can do as they wish with them. Whereas trusts are gifts with conditions attached. And as I've said, there's various different types of trusts, and it's just a question of working out what somebody wants to achieve, thinking about various tax issues, and working out what the best type of trust is for their particular situation.
Are there any other ways that people could protect assets?
Yes, there are some other things that an individual could think about. They're not watertight, but so much of what we do is sort of chipping away at an issue from, various angles. So, I mean, that if the deceased, for instance, had a joint property with a third party that they wanted to inherit that property, and it was held under what's called a joint tenancy, the terms of the will are completely irrelevant. When one of those co-owners die, the survivor automatically inherits the property. So on the face of it, that's not part of the net estate that could be subject to, an inheritance provision claim under the 1975 Act. But sort of coming back to that point we spoke about earlier, a potential claimant could convince the court to actually sort of posthumously sever that arrangement so that half is comprised in the estate and potentially a claim can be made in relation to that. But what you're effectively doing is you're putting in place extra hurdles that a potential claimant would have to overcome before they could even think about, right, now there's an asset in the estate that can theoretically be claimed against under an inheritance provision claim. So you're just making it that bit harder for them. The other type of asset, which isn't part of an estate against which a claim can be made, is a pension pot. And it's a method people have used for all kinds of reasons during their lives. I mean, obviously, we know people hopefully build up pension pots so that they've got something to live on when they stop working. But pensions can, afford protection if somebody were to be made insolvent, for instance, and they were wanting to shield funds from creditors. And the same applies, on death. What's in the pension pot can't then be claimed against under a 75 Act claim because the asset passes completely independently from the terms of your will. Part of the scheme structure is you will have nominated who's going to receive that pension. There's all kinds of different types of pension benefits. It's a specialised area in itself. But it's looking, when we work with people on estate planning and we talk about tax, protecting assets, achieving their objectives, we have to think about assets that pass under will, assets which don't, and strategies as to how to reduce the risk of a successful claim. And it can take many different forms.
Yeah, absolutely. So if we were to sort of summarize the key things, the key points that people ought to take away in terms of asset protection, whether it be because there's concern about a future claim or some other reason why they might want to have control over the ultimate destination of an asset. What would we say? I mean, it sounds to me that it's going to be very fact specific, so professional advice is going to be needed.
Yeah, I'm definitely. I mean, we do tend to think of life interest trust in particular when, trying to achieve protection and control and defeat a potential claim, or at least reduce the exposure to a potential claim for provision. But I increasingly raise it as an appropriate structure with all couples I speak to. You'd be amazed the number of times, I might have seen a couple for 30 years, for various reasons over the years. They get elderly, one dies, and it never ceases to surprise me. 6 months later or so, one of them will rock up, introduce me to their sort of childhood sweetheart, and announce they're going to live together or get married. And if you have a trust in place, you can, guard against the consequences of another family becoming, entitled to your estate one day. And you can equally guard against, if things go wrong with that relationship. So it's a sensible structure for most people, and it's so flexible that, if on the first death the structure seemed completely inappropriate, either in practical terms, desirability or taxation, they're worded in such a way that if all the trustees agreed, it could be broken and assets passed out right anyway. So it's kind of a win-win structure in the main.
Yes. Yeah.
And I think most wills for married couples should have that kind of protection in there. And it also assists with care home fee planning.
Yes. So in summary, I think what we're saying is that people need to think carefully about their own circumstances, take advice from legal and financial professionals when planning for the future and planning your wealth management. Plan for the unknown as well. Things don't always turn out as you expect. And communicate your wishes carefully together with your partners and spouses, cohabitees in particular, but also your wider family. And if you are setting up a trust, make sure you select those trustees carefully. So thank you for joining us today, Nadia. You've given us a lot of food for thought there. Obviously, if anybody wants more information about the topics we've been discussing today, head to our website at dmhstallard.com and do look out for the next episode of the DMH Stallard Private Wealth Podcast.